and Social Equality Symposium. So earlier we talked about building social movements one sport at a time, and now we're going to talk about something so incredibly exciting: antitrust. Woo! So I'm not going to monopolize too much of your time. I really could. I have a market power on puns, but just get ready. All right, so my name is Kaylin Wiedelman, and I'm the editor-in-chief of the Indiana Journal of Law and Social Equality. I'm going to introduce our moderator and then all of our panelists here today. Before I do so, I ask everyone your name tags before you today, if you could. So to begin, our moderator is the illustrious Professor Shauna Wallace. She is currently clerking for the Honorable Judge Hamilton of the 7th Circuit. She teaches antitrust and legal professions here at the law school. She was also an attorney at the best DOJ division, the antitrust division, for over a decade prior to coming to Maurer. She's already earned several accolades in her short time here, such as the Leonard Fromm Public Interest Award and the Most Interactive Professor Award, and she was selected to sing at the Singing for Summer Salaries last year. Most importantly, though, Professor Wallace played rugby and soccer at Amherst College a few years ago. So that's Professor Wallace. Our first panelist I'm going to introduce is Professor Jema Meyer. She teaches sports law and public policy at IU SPIA. She began her legal career as an attorney in the Bureau of Competition, FTC, in Washington, D.C. Professor Meyer has represented clients on antitrust and sports issues throughout the United States, including briefing in the U.S. Supreme Court. Professor Meyer has been named multiple times a New York super lawyer in the categories of antitrust and top women lawyers, and received the Distinguished Alumni Award from SPIA in 2014. Our second panelist is Miss Lisa Scanlon, who received her undergraduate degree from Marquette University and her MPA from here at IU SPIA. She then graduated from law school at the University of California, Hastings College of Law. She has served as an attorney for the United States Department of Justice for 21 years, and she is currently the Assistant Chief of the Litigation 3 section at the DOJ's Antitrust Division. Our third panelist is Mr. Jared Tiedemann, who received his undergraduate degree from the University of Nebraska, Lincoln, and his JD from IU Maurer. After law school, he served as a law clerk for the South Dakota Supreme Court, and then as an assistant attorney general for the South Dakota Office of the Attorney General. He currently works as the Director of Legal Affairs and Assistant General Counsel for the NCAA, or the National Collegiate Athletic Association. A fun fact about Mr. Jared Tiedemann is he was a managing editor on the best journal in the world, the Indiana Journal of Law and Social Equality, Volume 1. So he is actually to thank for our journal having Volume 7 now. All right, our fourth panelist is Professor Ed Edmonds from the University of Notre Dame Law School. He serves as director of the Kresge Law Library and professor of law in July 2006. Edmonds' primary scholarly interest involves antitrust and labor issues involving baseball. In particular, he has written and spoken about the trilogy of the U.S. Supreme Court cases, such as Federal Baseball v. National League, Toulson v. New York Yankees, and Flood v. Kuhn, that created baseball antitrust exemptions. Professor Edmonds would like everyone to know that he is a long-suffering fan of the Cincinnati Reds. And our final panelist needs no introduction. He is the illustrious Professor Kevin Brown. He is a sports law professor here, and he went to McKinney Law and then went to Yale. I got that. I got you. And graduated from Yale. I won't disclose the year, though. Professor Brown has many interests, but also roots for the Colts. Yay. All right, so let's go ahead and get started. Let's welcome our panelists and our moderator, Professor Wallace.
Thank you, Kaylin. Thank you to our panelists. To start with, so the NCAA is all about ensuring that our institutions of higher education have some common rules and understanding so that these institutions' sports teams can effectively compete against one another. After all, it makes no sense to talk about a sports league with their competitive teams if there's not an actually competently functioning sports league. Antitrust law is all about competition. We live in a largely market-based capitalist economy, and we believe that there should be some common rules and understandings so that our companies can effectively compete against one another. So putting the NCAA and the antitrust law together, as Olaf the Snowman would say, just makes so much sense. Not Frozen fans out here? No? Okay. I'll lend my daughter to you. So it makes so much sense, or does it? Based on the heated litigation that is taking place in this area, at least some people think that the ills that they've identified as coming from the NCAA's rules or its structure can be remedied by antitrust law. But we want to use our time as a panel to explore this intersection between antitrust law and collegiate sports further. We're lucky to have a group of panelists here today that approach this topic from very different areas of practice: government, academia, private practice, of course the NCAA. And what we'd like to start by doing is introducing some basic concepts that we're going to need in order to have that informed discussion. So we have Lisa Scanlon from the DOJ's Antitrust Division, and she's going to start by introducing us to some just basic terminology. To start here, how many people here have taken an antitrust class? Wonderful, yes, all of my students, that's great, okay. So,
how many students have had one class in antitrust? One session of one class, there we go.
There you go, right? That's great, that's great, that's great. It's an area of law that I strongly feel we should all be familiar with. But that being said, there's some terms of art that we use in antitrust that may not mean the same thing as when we use those terms in our common conversation: cartel, collusion. And so Lisa will help us kind of at least get our vocabulary straight. Ed Edmonds will then be talking about setting the scene for antitrust in sports leagues. Obviously, sports is kind of a weird animal in antitrust law. You need cooperation. You need some, for lack of a better word, collusion to have functioning sports leagues. So where has antitrust stepped in to assert itself and its role in looking at how sports leagues interact? And then Jared, who's here from the NCAA, can then locate the NCAA within this kind of universe that we've laid out. And we have Jama Meyer, who is our panel's private antitrust litigator, or litigator in general, but with an antitrust background as well, who can help then tag on with what Ed and Jared, et cetera. We're going to kind of give you the lay of the land for case law, what the recent litigation has been focused on, and where we think we're going to go from there. And our professor, Kevin Brown here, who teaches in the area of sports law, will be also, I hope, able to kind of, yeah, and race law, come in and address also where other issues that we might be concerned about may fit into this picture. I have to add, Kevin very graciously, we at the last minute lost a panelist, and so he is, as Kaylin said, calling an audible. She called an audible for us. So Kevin will be here as well. Lisa, would you mind starting us off?
Sure. Can you guys hear me? Yeah. Okay. Okay, thank you. So thanks, Shauna. Shauna asked me to do not even a mini lecture, but a micro lecture on antitrust. So as Kaylin mentioned, I work at the litigation 3 section of the Antitrust Division, and part of our portfolio is sports. And I'm a big sportsman. I started watching Purdue games, forgive me, when I was 6 years old, and now I watch mainly the Tour de France and my wife's hockey games. So that's where my sports viewing is now. I need to say that the views that I expressed today are not purported to reflect those of the U.S. Department of Justice. So it's on the record, I said it. So I want to talk about the Sherman Act for a few minutes. Congress passed Section 1 of the Sherman Act in 1890, and it outlaws all contracts, combinations, and conspiracies that unreasonably restrain interstate and foreign trade. Now, there are other antitrust laws, a handful of others, but for the discussion we're going to have today, the Sherman Act, Section 1 is kind of where it's at. So what does it mean to prove that a contract, combination, or conspiracy unreasonably restrains interstate or foreign trade? Well, first of all, you need an agreement among competitors. And to prove an agreement will vary depending on if you're in the civil or the criminal context. In the criminal context, we often think of smoke-filled rooms with competitors getting together and fixing prices, and maybe wiretaps of people coming up with bid rigging schemes. And we're looking there for a meeting of the minds or a mutual understanding between competitors to do something anti-competitive. In the civil context, which is where most of my work is, and really all of my work and most of the stuff we'll be talking about today, you're often looking at an open bylaw or rule of an organization of competitors. The NCAA has rules, and those rules can be about what size the football is going to be, to how bowl games are going to be allocated. And the real focus of antitrust is a really specific factual and economic analysis about whether an agreement among competitors unreasonably restrains trade. So the next part of that is what's unreasonable. I mean, if you think about it, every contract that you enter into is a restraint of trade. If you go work for law firm A and not law firm B, you're restraining your labor to law firm A, but law firm B isn't harmed, but competition's not harmed by that, right? That's a contract. If you buy a car from this guy down the street, not that guy, you made a contract with this guy, that guy doesn't get your money for your car, but it's fine, there's no harm to competition. A restraint of trade has to be unreasonable. And that's where the real analysis comes in. It's, does a restraint of trade lead to anti-competitive consequences? So in the criminal context, it's kind of an easy question because there's certain restraints of trade that can't be pro-competitive. If I fix prices with somebody for a market where we have market power, people are going to pay more for that good. I'm going to benefit, my co-conspirator is going to benefit, consumers are going to be harmed, you're going to pay more. So courts have said a price-fixing conspiracy is a per se restraint of trade. There's no further analysis that needs to happen once you've proved that. If I decide to bid rigs with somebody in a market where I decide I'll bid on this one and you'll bid on that one and we'll both benefit and customers don't benefit from competition, again, that's a naked or per se restraint of trade because there's just no pro-competitive outcome that can come from that. But much of the inquiry is a little deeper because we have to look at practices, and again, we'll get into it with these cases, of whether a restraint of trade is unreasonable. And oftentimes, rules of competitors, rules of the NCAA have pro-competitive reasons. Again, if we don't know what size of football we're going to have when we show up to play the game, we're not going to have a very good product. So rules about that are clearly pro-competitive, even though competitors have agreed that they're going to limit competition on what size football to have. But other inquiries have to go into, let's take a look at whether the rule on balance promotes or harms competition. And as we'll see through these cases, it's an extremely factual and economic analysis to figure out when a rule crosses that line from pro to anti-competitive. So that's the unreasonableness prong, I got it. The third element is whether the activity affects interstate commerce. And this is usually easily met. You know, if I fix prices on something and we have consumers all over the country buying these products, the interstate commerce is affected. If IU basketball games are broadcast in California and ads are sold in California, interstate commerce is affected. So that's a pretty easy test to meet. And the last thing I want to mention is market power. And market power is simply that the activity that I'm engaging with my competitor actually can affect the market. If I decide with my fellow panelists to fix the price of kittens, for example, you know, you can go get a kitten anywhere. We could decide to do that, but it's not going to affect the market for kittens. So I think we probably won't do that. But there, you know, if you look at the NCAA, that's where it is for college sports. They have market power for college sports, and there's nothing wrong with having market power, but with that comes the possibility that you're violating the antitrust law. So with that micro lecture, I'm going to turn it over to my fellow panelists.
Right. So
Ed, if you could, antitrust is not a stranger to sports leagues.
No, it certainly isn't. So, and I'm going to try to stay to the script, hopefully to stay within my time constraints, which I easily can get out of. So, really want to talk about sports and antitrust, and you really need to kind of start with baseball in the early part of the 20th century and talk about the trilogy of cases that created baseball's antitrust exemption. Now, at that time, this was, baseball was really the established professional team sport in the United States. Basketball, hockey, football, their development as major professional team sports are going to come later. In fact, in the 1920s, soccer was considered by many historians to be the next major team sport in the U.S., and I think most of us in this audience know that didn't turn out quite that way. But in 1922, seven years after the Federal League attempted to join both the National League and the American League as a third professional league at the top tier of organized baseball, after that kind of fell apart, crumbled, and dissolved, the United States Supreme Court considered an antitrust challenge to and one that actually created this foundation of baseball's exemption. Now, many of you might be familiar with both federal baseball, Toolson and Flood. What I want to submit today is that there's aspects of these cases that are misunderstood in very fundamental ways. So, in 1972, when Harry Blackmun wrote his opinion for the Flood versus Kuhn case, he mischaracterized, I think, dramatically within his first sentence, the federal baseball case, because he said for the third time in 50 years, the court is asked to rule that professional baseball's reserve system is within the reach of federal antitrust law. And next paragraph, I'm hopefully going to tell you why I don't think that's the case, because as Justice Oliver Wendell Holmes, who wrote the opinion in federal baseball, quickly pointed out at the very beginning of his opinion, the plaintiffs were primary shareholders in the Baltimore Terrapins franchise in the Federal League, and they sued the National League, the American League, all the teams within those two leagues, the presidents of the league, and Gary Herman, who formed the trio triumvirate that overruled or controlled Major League Baseball. They also sued James Gilmore, Harry Sinclair, and Charles Wiegman, who were involved in the Federal League. The case was really about the demise of the Federal League, which was brokered by all of those defendants that were sued by the syndicate that controlled the Federal League. So the case had been about the reserve system when it was in front of Judge Kennesaw Mountain Landis in Chicago, but not at the time it reached the Supreme Court. The second misconception, I think, about the case is that it's long stood for the proposition that it failed the third prong of the Sherman Act test, which is involvement in interstate commerce. And actually, Holmes, in his opinion, that's true. It did fail because of the fact that interstate commerce at that time was considered much more constrained than it soon began to be. But he also said, as it put by defendants, personal effort, not related to production, is not a subject of commerce. So in that sense, it would fail the second element of the test. And that which is not trade or commerce can't really be involved in interstate trade or commerce, because at the time, the manufacturing of goods and production was considered to be the major focus of Sherman Act violations. Let's move forward to World War II. During the period right after World War II, veterans were returning to baseball in the United States. Danny Gardella, who had played for the New York Giants, figured he wasn't going to have a roster spot. He joined a bunch of players. They went down to Mexico. Happy Chandler, who was the commissioner, disciplined them by banning them from being involved in organized baseball. And Gardella sued. If baseball's a national pastime, perhaps litigation is the second national pastime. And the Second Circuit, in a 2-1 split decision, remanded Gardella's case, which was dismissed at the trial level, back down for a trial. And Judge Jerome Frank, one of the three judges on that, penned one of the most memorable lines to me in sports law jurisprudence: "No one can treat as frivolous the argument that the Supreme Court's recent decisions have completely destroyed the vitality of federal baseball, decided 27 years ago, and have left that case but an impotent zombie. So Gardella, though, settled his case before trial, but it emboldened a number of others to bring a lawsuit. In 1953, a trilogy of cases made its way to the Supreme Court, one involving Earl Toulson against the New York Yankees. He's largely forgotten, often called George Toulson, which was his father's name and his given name, but he went by Earl. And the court there largely saying that they were concerned about the fact that Congress hadn't done anything about the antitrust exemption, the retrospective effect of it. They refused to overturn the federal baseball case. This case is really critically important because this is the case that really creates baseball's antitrust exemption, because prior to that, it would have been relatively easy, seeing the changes in the underlying principles, to overrule federal baseball. During the same decade of the 1950s, in 1955, 1959, in two different International Boxing Club versus United States cases, boxing was ruled to not be exempt from antitrust violation. And in 1957, football was also given similar treatment in Radovich versus the National Football League, when they said that it's not involved in, or they are not going to be exempt from antitrust law like baseball was. In 1971, Spencer Haywood brought a lawsuit. The court said the NBA doesn't get this exemption. And a year later, the National Hockey League lost an antitrust challenge in the district court in Philadelphia World Hockey Club. So you see all these other sports are being treated differently than baseball. So comes back to the Supreme Court for the third time, as I mentioned, in Flood versus Kuhn. And there, in a 5-3 decision, they said, you know, professional baseball is a business, and it is now engaged in interstate commerce, but its reserve system has enjoyed exemption from federal antitrust law. Baseball is in a very distinct sense an exception and an anomaly. Federal baseball and Toulson have become an aberration, confined to baseball, an aberration fully entitled to the benefit of stare decisis. So, interestingly, 3 years later, Southern District Court of New York actually followed something that came up in Justice Thurgood Marshall's dissent in Flood and said, wait a second, there may be another exemption that's important here, and that's the non-statutory labor exemption, and in Robertson versus NBA, and then in Mackey versus the National Football League, those cases dealt with whether or not the labor exemption should really trump the antitrust exemption. And ultimately, years later in Brown versus Pro Football, you see that labor laws really become what's important. So two other things, and then I'll be quiet for a minute, that set up this discussion about the NCAA and its relationship to antitrust law, and talk about two cases very briefly that set up the O'Bannon, Jenkins, the litigation of the past decade. In 1984, the U.S. Supreme Court case had, the U.S. Supreme Court had an opportunity to render an opinion in NCAA versus Board of Regents, where they agreed that both the universities of Oklahoma and Georgia, who had sued on behalf of College Football Association, which really were the major, what we would call now the Power Five conference, that the restraint on the limitations on the number of live games that could be broadcast constituted an unreasonable restraint of trade, because it was a limitation on output. And when I talk about this case to my students at Notre Dame, many of them are shocked that when I first started as an undergraduate there in 1969, you could get 2, maybe 3 cases on a Saturday. Last time I checked this fall, there were 40 cases over my cable system on Saturday alone. And certainly the University of Toledo, where I went to law school, was not playing on Wednesday and Thursday nights in the middle of the week, because that's the only place that the Mid-American Conference can get some TV exposure and make some money. The other major case that was involved here, Law versus the NCAA, was a situation where caps on the salaries of a select group of part-time college coaches was found to be a violation of antitrust law. So then briefly, Congress has stepped in on a few occasions, and so I'll list a little bit of that. In 1961, they passed the Sports Broadcasting Act, largely to favor the National Football League, which in the 1950s had 2 cases for its pooling of its TV plan run awry of the Department of Justice and the Antitrust Division. So they got Congress to step in and enact something which actually also covered baseball, which didn't really need an antitrust exemption, basketball and hockey, reserved Friday nights for high school football and Saturday for college football. It's actually not just custom, there's a legal authority for that. Then in 1966, the National Football League and the American Football League wanted to merge. That required congressional approval because they wanted to make sure that they were exempt in that combination from antitrust challenge. And then the Amateur Sports Act of 1978, now known as, after its 1988 amendments, as the Ted Stevens Olympic and Amateur Sports Act, that approved the structure of national governing bodies of Olympic sports and gives them a tremendous amount of power and control over those sports. And then the last thing I'll talk about, in 1988, the Curt Flood Act was passed, which provides a very narrow repeal of Major League Baseball's exemptions solely related to the relationship between Major League Baseball and professional players at the highest level. Courts have actually looked at this and felt that it actually reinforced baseball's antitrust exemption beyond all of the labor relationships, which, by the way, are protected by the non-statutory labor exemption. And recently in the City of San Jose case, the Curt Flood Act was used as one of the reasons that baseball was exempt from antitrust challenge in a franchise relocation case. So that's hopefully in a nutshell a little bit of a start on an understanding of where sports have intersected with antitrust law.
Yes. And Jared, I'm sure you were relieved to hear that the DOJ is not looking into the NCAA criminally, and so you can take that back.
Lisa got here, I got nervous. No,
It happens.
I was not. Yeah, thank you, and thank you for the introduction. It's good to be back here. It's good to see this journal thriving. I was on, I think, the first symposium of this, so it's good to see that this is a great turnout, so it's really awesome to see, and kudos to the journal members for setting this up. I really appreciate it. So I thought that I would start, we've just had this long conversation about antitrust law, and it'll continue. But one of the important places to start is, what is the NCAA? What does the NCAA do? What does it not do, right? So to understand the NCAA in the context of antitrust law, we have to understand the structure of the NCAA. And so the NCAA is a voluntary nonprofit association. It's made up of 1,100 member colleges and over 100 conferences like the Big Ten Conference. There are about 500,000 or close to 500,000 student athletes that participate in NCAA athletics. So it's a pretty significant group that is served by the NCAA and by its members. The significance of the NCAA membership is that the NCAA members that actually create the rules. There's a national office in Indianapolis where there are 500 employees, but it's the NCAA members that actually agree on the bylaws and decide what rules are going to govern the NCAA. The NCAA is divided into 3 divisions, Division I, Division II, and Division III, and each division has some of their own distinct rules. But generally the rules cover things like academics, financial aid, playing rules, practice times, etc. So there's a whole scope, broad scope, and the manual is fairly significant for those of you that have had to read it. Hopefully not as homework in JAMA's class, but hope not. So that's kind of the background context. The NCAA National Office administers about 90 championships. One of the championships that the NCAA does not administer is the College Football Playoff. So the College Football Playoff, formerly the BCS, is operated separately by the College Football Playoff and administered primarily by the NCAA conferences. So the revenue derived from the College Football Playoff does not go back to the NCAA to be distributed. It goes directly to the conferences. The NCAA generates most of its revenue from the March Madness contract that you may hear about later with Turner and CBS, and you'll probably hear about that number. And most of that number, right, it's close to $1 billion, goes back to the NCAA membership. It does not sit in the coffers in Indianapolis. I promise you it doesn't. It goes back to the NCAA membership. And yearly, the NCAA and its members, I think, fund somewhere in the neighborhood of $2.7 billion in athletic scholarships. So significant opportunities are created through college sports. And that's kind of the unique prism in which the courts have looked at this, right? College sports is very unique to America. This notion that you can play sports in college, get a full ride scholarship to play sports, and then also get an education at the same time is fairly unique to America. So within that prism, that's how courts have looked at this question, right? What is it about college sports and the NCAA that makes it a unique product? So one of the things that, we talked about the Board of Regents case, and you'll probably hear a lot about that case going forward because it's, the one time, the U.S. Supreme Court looked at the NCAA and antitrust and said, here's the kind of test that we think should apply going forward, and here's how the NCAA should be viewed when it comes to antitrust scrutiny. So when we're talking about antitrust and the NCAA, we have to look at a number of different rule possibilities, right? So on the one hand, we have some rules that are primarily focused on eligibility. So the NCAA has faced challenges to its transfer rules. Most recently, the Seventh Circuit heard a case about the NCAA's transfer rules, which require a student athlete at the Division I level in certain sports to serve a year in residence. What that means is if you transfer from one Division I school to another Division I school, in like a sport like football, you have to sit a year of competition. That was challenged on antitrust grounds, and ultimately NCAA prevailed because the Seventh Circuit looked at it and said, this upholds the NCAA's pro-competitive justification of amateurism. So amateurism, right, that's in the title. That's one of the critical things that the NCAA has used in defense of antitrust lawsuits. And the U.S. Supreme Court in Board of Regents, despite the NCAA losing, had a lot of dicta that focused on the NCAA's role in preserving amateurism. Specifically, the court looked at the fact that the NCAA has a unique role, right? That there has to be some, I think the quote is, there has to be some level of horizontal restrictions on competition if the product is to be available at all. That is to say, the NCAA has to have some rules to govern its members if there's to be some kind of competition at all, right? You want the members to be playing on, to keep the sports puns going, a level playing field. So understanding that, the court went on to look at the fact that the NCAA should get ample latitude when it comes to its eligibility rules and its rules governing its structure, because ultimately the NCAA and its pro-competitive justification is defending amateurism. And the courts have said that amateurism is interleague sport. So when we're talking about that, we'll look at that conversation. You'll hear a lot as well about the rule of reason and the pro-competitive justifications versus the anti-competitive effects of a rule. And Jamie will talk about it in more depth, but amateurism has been one of the NCAA's biggest pro-competitive justifications for maintaining its rules and the ability to defend itself in antitrust challenges. Another one that Jamie will probably get into is academic integration. That is the fact that there's again, they're student athletes, right? So there's a component where you go to class and you also play sports, and you want the whole component to be athletics to be integrated in the whole student experience. So those are the primary defenses the NCAA has used within its structure when it comes to antitrust challenges. And I think I'll turn it to Jamie to talk about some of the more specific case law and how that's been used.
So before I get to the specific most recent cases, I'd just like to point out and emphasize two sort of overarching principles that have been touched upon. Here in the United States, we believe in the free economy. Our system is dictated by competitors competing with each other. Samsung and Apple could not agree on how much they would pay their CEOs. They could not agree on how much they would pay all their engineers. That's viewed as anti-competitive. The antitrust laws prohibit that. And then secondly, as Jared said, we do have this unusual product in the United States, college athletics. And the real question here is not the application of antitrust laws to a narrow set of rules. The real question that we all really should be thinking about, I would suggest, is how do we preserve college athletics within this construct of mostly nonprofit organizations? And we really should be looking at the rules relating to academic fraud, the safety rules. And then there are the rules that come that come out of or relate to the commercialization of college athletics. Now, commercialization's always been there. There have been reports since the NCAA was discovered in 1905 saying, oh yes, athletes are being paid and they shouldn't be paid. There's too much money involved in college athletics. But it's really come to the front now because as a result of the Board of Regents case, there are all these TV rights, and colleges and conferences are making an enormous amount of money from those rights, from the exposure of college athletes on TV. So the question then has arisen, especially over the last 10 years, well, where does this money get spent? Well, it's being increasingly spent on coaches. We all know the reports about the coaches, the Sabins of the world, Coach K, et cetera, receiving $8, $9, $10 million a year. We've heard of the reports about and see the lavish facilities. Some of the big football programs like Clemson and Alabama have these $40, $50 million palaces just for the football players, where they have laser tag facilities, bowling alleys, barbershops. You could go on and on about how that money is being spent within a nonprofit organization and whether that's the proper use of those monies. Therefore, elite athletes are stepping up and saying, this money is going to the coaches, going to facilities. Well, why shouldn't I also get some of that money? So how do I do that? One method is through the antitrust laws. Now, there are other methods that are also being applied. There are attempts to unionize by the athletes. You're probably familiar with the attempt at Northwestern, where the football players attempted to unionize, and in the end, the National Relations Labor Board said, sorry, but this is really not our jurisdiction. It'll just confuse matters if we rule on this. Maybe Congress should look at this. There have been attempts by players to fall under the labor laws and be declared as employees, that they would want to have the same rights as employees do at corporations. Now that's a mixed bag, because then the athletes are going to have to pay taxes on what they're paid, and there'll be other complications of that. And thus far, athletes have not been deemed, college athletes have not been deemed to be employees. So we get to this question of compensation, and it really is a question that relates only to the elite athletes in elite programs. For the most part, most of these 480,000 athletes, athletes in college right now are getting a great deal. They're getting tuition, room, board, expenses, etc. That's a great deal for most athletes. But for some elite athletes in elite programs, should they share in this enormous amount of money that's being made? So the O'Bannon case is one of the most recent decisions on this issue. In 2009, the case was filed. Ed O'Bannon was a former UCLA basketball player. He went to a friend's house. The friend's son was playing Madden in basketball. And Ed O'Bannon saw his image in the game. And he said, crap, why is, EA, the developer of the game, the NCAA, the schools, they're all profiting from my image. Why shouldn't I also get some of that money? But there's a rule, an NCAA rule, that says athletes cannot be paid for their name, images, and likenesses. So he sued the NCAA. This is 2009. 2015, the district court decides the case. The district court, that is Judge Claudia Wilkin, found that, yes, there's an anti-competitive effect. She applied the rule of reason based on Board of Regents. That's what we need to do. If this were done by private entities, producing iPhones, it would be definitely per se illegal. But because it's college athletics, we're going to apply the rule of reason, and we're going to let the NCAA justify its rules. So the NCAA had 4 justifications. The court accepted 2. Jared alluded to them already. Amateurism, these rules, because athletes are not paid, then they're amateurs, and if they're amateurs, then the public will like the sport and go watch it. And if they're paid, the public's not going to come and watch the athletes. Demand will go down. On the integration, if the athletes are paid, they're not going to be integrated with the student body, as if in these elite programs they are really integrated now, but we'll put that part aside. So these two justifications were upheld, although she didn't wholeheartedly uphold them. She said, well, there's some justification here. At that point, after the NCAA proved two pro-competitive justifications, the burden then shifts back to the plaintiff to show whether there are less restrictive alternatives. That is, an alternative rule that would satisfy those pro-justifications, but not be so restrictive, and also would not be as costly. So she found two less restrictive alternatives. One was, we're going to let the athletes receive an additional stipend called a cost of attendance stipend. It ranges between $2,500 and $6,000. The guidelines for it are actually set by the federal government, related initially to only academic scholarships. So if, the cost to attend IU is different than the cost to attend NYU, and we're going to account for that. And we're going to give those cash stipends to athletes. We're going to permit that. There was a rule prohibiting it. We're not going to tell the schools you must do it, but we will permit it. The other less restrictive alternative she found was, we'll give a $5,000 stipend to be held in trust to the athletes that have sued. It's $5,000 per year that would come out of group licensing fees. We will permit that again. It's permission. It's not a dictation that you must do it. That goes up to the Ninth Circuit. The Ninth Circuit basically follows the same line of reasoning, says those pro-competitive justifications are valid, but we don't like that $5,000 stipend. It's not tethered to education, and it would be this quantum leap if we started giving cash to athletes, even if they don't get the cash until after they leave school, not graduate, leave school eligible, although we will allow the COA payments. So this was a big loss for the NCAA, because for the first time, a court, other than the law court, the law decision which dealt with restriction of coaches, assistant coaches' salaries, found that clearly the Sherman Act applies to eligibility rules. This is commercial activity here. There's a lot of money. We're not going to buy this excuse that it's an eligibility rule, therefore the Sherman Act doesn't apply. It was a win at the Ninth Circuit for the NCAA because the $5,000 stipend was not upheld. Both sides appealed. Both sides had won and lost a little bit. Both sides appealed to the Supreme Court. Supreme Court didn't accept cert. Now, boiling during the same time period were additional cases that did not relate just to NILs, name, image, and likeness payments. So people woke up and said, well, why shouldn't we use the antitrust laws to get rid of all of those rules that prohibit any kind of cash payment to athletes? Suits were filed all over the country. Many of the suits sought monetary relief. That is, athletes wanted that COA payment for the time when they were in school. So that was the monetary part. And then injunctive part, which would prohibit those NCAA rules that prohibited compensation. There was one case that only dealt with injunctive relief, didn't sue for monetary relief. This is a little bit in the weeds, but for those lawyers in the room, the cases all got coordinated in the Northern District of California, again before Judge Wilkins, same judge that had just decided the O'Bannon case. The cases that sought monetary relief that had been coordinated and actually by that point consolidated into one complaint settled the monetary part. So $208 million for $208 million. So that's being distributed, I think it already has been distributed to athletes during a certain time period who didn't receive the COA payment. The other part is the injunctive relief, prohibiting all rules by the NCAA that limit compensation to athletes. That case along with, so there's a consolidated group of cases, and then a separate case that only sought injunctive relief, which is known as the Jenkins case. And that's an important case because of its lawyer, Jeffrey Kessler, who's a renowned sports lawyer, has dealt with free agency issues in various professional sports, et cetera. Those cases were coordinated for trial, or for discovery purposes, actually. It's a little more complicated than that, but we don't need to get into those complications. So there were 10 days of trial in the fall. There was final oral argument on December 18th. The NCAA raised again the same pro-competitive justifications, integration and amateurism. Now, we're before the same judge again. Remember, we don't know what she's going to rule. She's been very skeptical this time about those pro-competitive justifications. She's been really questioning them. The plaintiffs have been pointing out to her all of the rules that allow for some compensation that actually are not tethered in their minds to education. So for instance, the NCAA this past year had a fund called the Student Assistance Fund. It had $84 million in that. That money can go to schools, and the schools can decide how to distribute that to the athletes. And there are some guidelines. Originally, it was for emergencies. So if an athlete's mom died, they could fly them home, pay for them to fly home and go to the funeral. But it's morphed into much more than that. And in fact, some schools are using that fund to pay for things like loss of value insurance. I'm sure you all saw what happened to Zion Williamson, unfortunately, recently, and the press about the fact, well, at least if he gets injured now, he did have loss of value insurance for if he couldn't get drafted as high in the professional league once he left colleges. Well, those premiums are enormous. Those premiums are like $40,000, $50,000 a year. Obviously, Zion couldn't pay that kind of money. So either Duke pays it directly, or the student athletic fund money that comes from the NCAA, then Duke can give to him. So the question is that tethered to education? You know, so the plaintiffs showed the judge all these circumstances where there actually are payments now. So what is the proper rule that the NCAA should have? Should there be any limits on compensation? They're saying no. That would be their first, and that's what they really want this court to do, enjoin all rules. But then they realize, you know, they've got problems with the Ninth Circuit language about being tethered to education. So the second and third alternatives really relate to putting caps on all kinds of additional rules that are somehow incidental to participation in athletics or tethered to education. So that's sitting there. A decision should come down any day. A lot of people thought that maybe the work, that the clerks weren't working in January because they're federally employed clerks, but that decision should come down any day. Couple of things, though, that do relate to this that I just want you all to be aware. Once athletes are paid, and these suits are brought by FBS football players generally and D1 basketball players, men's and women, although the Jenkins case didn't include women. But there are great Title IX questions here that maybe we'll hear about a little bit later, that if the guys are paid, the girls have to, equitably be paid also, equally be paid. You can expect this to go up to the Ninth Circuit and probably even up to the Supreme Court. And we can talk later about possible solutions, because I don't think that this piecemeal litigation is sort of a whack-a-mole approach as to the, using the antitrust laws to enjoin certain rules is really the way to look at this. We really need to do something more holistically.
Professor Brown?
Actually, I was talking to the faculty athletic representative of IU, and they indicated that they believe that the reason she's holding up the case is to wait and deliver it during the men's basketball tournament. This issue here, let me start with one statistic, Indiana University. 98.2% of the revenue of the athletic department comes from basketball and football. 98.2%. That basically means that men's basketball, men's football is producing all of the revenue to pay not just the coaches in football and basketball and the scholarships for football and basketball athletes, but for all other athletes, bowling, golf, skiing, whatever, as well as the facilities. So when IU added luxury boxes to the football stadium and to the basketball stadium for alumni and the officers of the university, those revenues were being generated by football and basketball. So one of the first issues you've got to decide is how are you going to look at college athletics? Are you going to look at it as all college athletic teams, or are you going to say, no, 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 that's wrong? There are two sports that are revenue sports, and then there are the other sports that are participatory sports. The participatory sports are primarily for the benefit of the athletes who want to play, but the revenue sports are the ones that actually generate the money. And part of what is a problem with this issue of whether or not we should pay athletes, and keep in mind this is a debate that's been going on for over 30 years. Part of the problem is we as Americans think it is fundamentally wrong for the individual to sacrifice the individual's interest for the benefit of the group. And what we are watching are the basketball and football players sacrificing their interests, not just for athletes in non-revenue sports, coaches in non-revenue sports, facilities, but also students who don't have to pay as much money for the tickets. Alumni who can come down here, they don't have to pay as much money. So we're watching, in some sense, this fundamental breach of American values of individuals sacrificing for the interest of the group. Should athletes be paid? Now, one of the things I like about how you put me at the end is there's no race issue in antitrust law. But yet this is a conference about the intersection of social justice and athletics. So let me introduce the race issue. 55.9% of FBS football players are black. 53% of D1 men's basketball players are black. Look around this room, and you sort of see about the same thing that happens in most college campuses and universities. If this was a room of basketball and football players, half of the people in here would be black. But because it's the entire campus, blacks are about 3 or 4%. So you can see the racial disparity that exists here. Indeed, a Marist poll from 2016 indicated that 53% of blacks believe revenue sports athletes should be paid, compared to only 25% of whites. So, most people, when they look at this issue of whether or not the athletes should be paid, look at it and figure they got one of two choices. One, we pay the athletes. But let's say we do that. Let's say they strike down the NCAA's ability to limit compensation, and it's up to the colleges and universities to decide to pay the athletes. Well, you're a college and university, what are you going to do? Well, the first thing you want to think about is, if we start to pay the athletes, could that mean that the money we generate from revenue sports becomes taxable for federal income tax purposes? In other words, could paying the athletes trigger a conclusion by the IRS that the money that colleges and universities that are dedicated to education receive is unrelated business income and therefore subject to tax? I'm not saying it'll happen, but I'm saying this is an issue you'll have to look at. Well, what else would you have to look at? Well, if you pay them, you've got federal income tax implications, right? Because if you pay the athletes its income, they're going to have to pay taxes on it. They're going to have to pay state taxes on it. They're going to have to pay Social Security taxes on it. You're going to have to pay Social Security taxes on it. You're going to have to pay state unemployment. Now these athletes are going to be governed and covered by workmen's compensation law. Everyone knows the whole power of the NCAA was to prevent the athletes from being covered by workmen's compensation law. Why? Because the colleges and universities didn't want to be stuck with all of the medical expenses from all of their injured athletes that might be permanent injuries. So that's if you want to pay them. let's say you don't. Let's say you say, no, they're getting enough money through the scholarship that we shouldn't pay them. Well, that's true today. But think about how the money's been increasing that's coming into college sports. 2012, the deal to televise the college football playoff series brought in a television contract of $5.6 billion. In 2010, the NCAA signed a new television deal that increased the revenue 41% over the prior deal. And just a couple of years ago, the NCAA then signed an extension that added an additional $8 billion to that deal. Between 2005 and 2015, the Power Five conferences increased their revenues by 266%. We know that there are internet platforms out there like Google and Amazon that are going to pick up sports and increase the revenue in college sports. So let's say today you say you shouldn't pay the athletes. What are you going to say 10 years from now when all this additional money continues to flow into college sports? Plus, you're right. The deal should be athletes should graduate if they come to colleges and universities. And we should give credit to the NCAA and its member institutions for substantially improving the college graduation rate of the athletes. The NCAA has worked with the colleges have worked very hard to improve the educational credentials and situation of athletes. So between 1991 and 2017, we saw an increase in the percentage of black male basketball players that graduated from 29% to 49%. For FBS football, we saw it move from 35% to 60%. Now keep in mind also, black male basketball and football players graduate at higher rates than non-black male students on their college campuses. So how much more room is there for continuing to improve the graduation rates, even as you watch the revenue continue to expand? So this is where I now introduce the race element, although you think I may have already. I actually have not. I am a black male. Make no mistake about it, being a black male, I am connected to the black community. What happens in the black community will also affect me. Black football and basketball players are not living a separate existence from mine. I cannot begin to tell you how many people have asked me throughout my life, did you play football? Okay? Yeah. Football is an extremely violent sport. There's no question about it, right? It's organized violence. Every Saturday and Sunday, Americans are watching black males in a violent sport. And what is the image that they're getting of black males when they watch it? We're violent people. So one of the outcomes of the importance of sports in this society is, of course, the overrepresentation of black males in the criminal justice system. 35% of the people in our criminal justice system are black males. Indeed, a black male has a 1 in 3 chance of spending some time in jail. Now just think about that for just a minute. A 1 in 3 chance of spending some time in jail. Now, I'm kind of trying to paint the picture that I think we'll continue to debate this issue about whether or not the athletes get paid and don't get paid. There are tremendous legal obstacles to paying the athletes. Yet as we debate this, the revenue is going to continue to increase. More money is going to flow in through athletics into the colleges and universities. What I would like to suggest is an alternative, and also as a football and basketball fan. Admittedly, I started IU in 1974. So if you guys know, 1974 was the year we lost only 1 basketball game. 75, 76, I'm getting all choked up about this. We were undefeated. So I love the sport. but I'm very troubled about the money. So what I would like to suggest is that the NCAA divert some of these rising funds that they're receiving to increase the college attendance rates and graduation rates of the Black community. I could give you a whole set of statistics about how we're less likely to graduate. When we do graduate, it takes a longer period of time. We borrow more money to do so. So I guess in the end, I want to conclude that I don't see how this dilemma gets resolved as long as we conceptualize this with the money going either to the colleges or to the athletes. There's a separate interest in here altogether, and that is the independent interest of the Black community. Thank you.
So I think Professor Brown's points tee up nicely the fact that in terms of people having concerns about these issues, should there be something uncomfortable about the fact that the litigation that's made the most progress in this area is antitrust litigation, which he's absolutely right. It has nothing to do with social equality. If anything is supposed to be aimed at, it seems to have apparently in large ways failed, but economic equality of opportunity. And I can say as an antitrust lawyer, one of the things that has always struck me as particularly hard to get my mind around for these types of litigation, and it comes from the NCAA Supreme Court case, is this focus on amateurism as a product. I cannot think option. I know it would cost less. And so where are we going to end up with this? Is antitrust the right way to achieve the goals we may have in mind for reform here?
Well, I definitely do not think antitrust law is the right way to go about it, because there are lots of consequences from changing rules, and we need to do this holistically. And it's not really free labor. A lot, getting tuition, room, board, books, etc., is what they are receiving. Most athletes, all athletes, are receiving for playing. So they're getting some form of compensation. The only question is there a certain portion of athletes who should receive more than they get now? And they are. But what are the consequences of that? What are the Title IX consequences? We need to address the safety concerns. We need to address the academic fraud. If we want to talk about, which we should, the race problem, we should talk about, are there too many special admits for Black athletes? Are Black athletes receiving, are being forced to go to certain types of classes, receiving too much tutoring, receiving, going to fake classes, etc.? It's a big problem. We need to figure out how we can preserve the college athletic scene that we love and do it appropriately within the context of nonprofit organizations. We're looking at just a tiny part of this puzzle. We're looking at piecemeal attacks. The courts are micromanaging this whole scene of college athletics. And I don't think that the membership, the NCAA, is going to agree on how to divvy up the revenues much better than they already have. I think we need, like what happened with the Olympics. It used to be you had to be an amateur to participate in the Olympics. There was a presidential commission appointed, a holistic approach to it. Now you don't have to be an amateur to compete in the Olympics. And by the way, demand for the Olympics has gone up, not down, as a result of the athletes receiving more compensation. But so there are big questions here that I suggest that Congress needs to look at, and then there needs to be some kind of conditional and limited antitrust exemption, like some of the professional leagues, or there have been situations of limited exemptions in other circumstances. And then you could condition the exemption on safety concerns, for instance, being required.
Actually, Lisa, quickly, this discussion of antitrust exemptions. I mean, obviously, this has been a whole area, decade more long, of antitrust litigation that has not seen an appearance by the government at all, even though, we typically made it our business to weigh in. I mean, do you have thoughts on whether there is a role for government enforcement here, and if so, what, or why there'd be more an effort at refraining from it?
I mean, I think the difficulty is that antitrust is mainly common law. I mean, the Sherman Act is a short statute, and there's a few other statutes. And so there's a body of law that's been developed and a body of economics that has been developed alongside it, and that has shifted, from one perspective to a more, I would think it would be fair to say, conservative perspective about how the economic analysis in antitrust. And so I think getting creative in terms of remedies is a really hard thing if you're doing an antitrust challenge to these rules, because you're constrained by case law, and you're constrained by the analysis about looking at pro-competitive justifications and efficiencies. And so it's not necessarily the right tool, because, as Jama was saying, if you consider this to be a problem, to come up with a solution that can be creative, as Professor Brown was discussing. Antitrust is more of a precision tool, I think, that kind of goes around the edges instead of sort of getting into there and really digging into under the engine. So I think it's a tough way to go about it.
And if I could jump in for just a second, I mean, one of the things that fuels the desire to have antitrust litigation is the fact that you have treble damages. And so that's part of what is fueling this. And by the way, if some of you who are law students are wondering, why you entered this enterprise, let me just say one thing about the O'Bannon case. I think Ed O'Bannon made, ultimately in the settlement, a very small amount of money. The attorneys who brought that action made $40 million. Judge Wilkin approved attorney's fees of $40 million for that group. So in case you're trying to think about which part of this enterprise you want to engage in. And then just one other quick thing that interestingly, Jama, in Judge Bybee's decision, he acted like a change in the Olympics was, a change in college athletics would be far more dramatic than the change in the Olympics. And I would submit that Judge Bybee doesn't know much about the history of the Olympic movement. You don't get somebody like Michael Phelps in multiple Olympics until you change the fact that it's professional and there was a revenue stream created to support those athletes over multiple Olympics. If you look back in history, there weren't very many Olympians outside of something like dressage, since that came up earlier this morning. The equestrian events that were in multiple Olympics. Somebody who looks even close to my age could be riding a horse in one of those events.
Professor Brown.
Let me also say about antitrust. So I think everybody would agree that the athletes won in the O'Bannon case, but the athletes were Division I men's basketball players and FBS football players. So when it then came back, and there are clearly Title IX issues here, but when it then came back to the athletic directors to institute what they're going to do, they raised all athletes scholarship, not just those in basketball and football. So the litigation by basketball and football goes on to help all athletes.
Jared, did you want to add something before we go out to the audience?
No, we can go to questions, so I might have some.
You have perfect. Professor Dowschmidt?
Just a quick comment on this kind of choice of legal remedy. I have thought about this because I followed, of course, the Northwestern football players case. I teach labor and employment law, and certainly didn't see the NLRB failing to take jurisdiction. But if you look at the solutions, back when they treated it as employment and they were talking about collective bargaining, the players at least were talking about things like insurance and loss of value insurance and things like that. And so you could imagine, how is this going to resolve? Well, it's going to resolve itself with the players as a whole bargaining on behalf of benefits for all players. And maybe some players would get more benefits than others, or something. Loss of value insurance is worth more to people that actually have value to lose. But now it's gone to antitrust. and use of your image and kind of a property right. And so we're not going to see, at least not out of the private solution, we're not going to see a collective solution out of this. We're going to see people with individual rights. My image is worth more than your image. I'm going to be paid for my image. And what I do with that money, who knows, you know? So the kind of the choice of remedy here, or the choice of which law applies, I think is going to affect what kind of remedy we see out of this situation.
Oh, great. I don't know what. Oh, perfect. He's coming this way.
I'm not a lawyer, so I don't know whether this is even a ballpark question, but it has to do with collusion. All right? Hypothetical. If there were 129 institutions who got together and threatened to leave the NCAA if they didn't get a certain percentage of the revenues, or if the NCAA started a championship in competition with the college football playoff, is there any, and are there any antitrust implications for that kind of a hypothetical?
I'm going to save Lisa from weighing in on predicting future enforcement efforts. Look, from the antitrust perspective, that's actually been a very active area over the last few years in looking at collusion among employers in terms of setting employees' salaries and rates. So you had eBay, Disney, Pixar. You had a whole bunch of big tech companies all facing treble damages and paying them for colluding to not compete for each other's engineers. So trying to say that somehow this is analytically incompatible with, very in the forefront litigation efforts in the antitrust arena doesn't quite fit. Now, then you get into the sports league question, though. Is it colluding to have the schools and the teams making these agreements? Well, how necessary is that collusion to have a viable product? And do you actually only need one NCAA? Do you actually only need one, this is where Jared will understand more about how the NCAA overlays with competing sports conferences. But could you imagine different business models coming up in different areas of the country or different sports or whatever else? It is, we should feel not alarmed that different people may be paid differently based on what they're contributing to an organization. That tends to be how we, the rest of us mere mortals, live our lives. And so but again, then you run into Title IX. At the end of the day, are our educational institutions meant to be running professional sports leagues? I don't know, right? But yes, you can imagine.
Did the hypothetical I just described, did that describe collusion that depressed commerce?
Yes, but if you're going to already concede that you're in this rule of reason land, what was the pro-competitive benefit for that collusion? And this is where, again, I get stuck because you're like, well, did it promote free labor? I don't know.
The pro-competitive benefit is 100% profit from the college football playoff, which was the result of them owning that property.
Right. Right. I mean, it would be an interesting litigation. Right.
Owning it and distributing it. I mean, the entire organization.
Right. And so if that was actually an antitrust case bought, and Jema, you could weigh in here on how litigation-wise you'd need to be going through discovery and I guess probably litigating over whether or not someone could come up with some sort of pro-competitive justification that would pass muster. Jema.
Yeah, well, I don't know if I have a lot to add to that. I mean, I guess you could start to think about, is there some kind of group boycott here? Or also start thinking about, well, not answering your question directly, what if the conferences, not a national body, but certain conferences, can they get together and agree to have those? So that, yeah. But even now, given the Jenkins and Alston cases, is that going to be acceptable, or is that another kind of antitrust violation? How much power do they have, and then what are they trying to do? What are you guys going to say justifies that behavior? Although I guess you might not necessarily be a defendant in those cases. No. It would be suits against the conferences, or just those conferences that threaten to leave, or just those conferences that support the college playoff ball, or whatever it is.
I mean, I'm trying to kind of get the hypothetical. I mean, one of the conversations in the Alston case is whether the conferences should be able to set their own eligibility rules, right? So they should be removed from the eligibility rules, and the Big 12 should get to set its own financial aid rules for the Big 12, the Big 10 set its own financial aid rules for the Big 10, et cetera. The difficulty is, of course, that, in our opinion, changes the product, right? Because if the Big 10 and the Pac-12 or the SEC, they play each other, right? Well, if they now have different rules, no longer is the playing field level. And so you need to have a sports league that governs sort of a set of rules, right, and creates an even playing field. So that's kind of our position on that.
Because they think the playing field is level now.
Hey, Loyola Chicago was in the Final Four.
Yeah. Professor Singleton, I think we may be giving you, we started a little late, so I think we may be giving you our last question.
Okay, can everybody hear me? I guess you
Yes.
can. I can't hear me, though. Anyway, this is a question for the representative of the NCAA. Professor Brown has mentioned Division I football players and basketball players. And I think there are 3 divisions.
Correct.
Lots of money comes in. Does any of that money ever get to Division II and Division III schools?
Yes, it does. And the make of a Division III is slightly different because Division III does not offer athletic scholarships. So you can't consider athletics when awarding financial aid. So a lot of that money goes to administering championships, et cetera, at the Division III level. A lot of the money goes to Division I, right? It trickles down in portions, and a good chunk goes to Division II. I don't know the specifics on the numbers. I want to say it's something like one of them I think is 38 million. So yeah, that goes down to Division I, Division II, and Division III, in a certain percentage. Yeah. It's a formula where Division I gets more.
But it's really
smaller. Yeah.
And it was a condition of the deal with 29 institutions.
So I would love to talk about this further, but I'd like to thank the panelists for joining us from all over.